Imagine a legal system where breaking the law is the first step to being protected by it, where a burglar injures himself in your home and has a legitimate case to sue you. This isn't fiction. We have found 50 real laws and bizarre legal loopholes that seem designed to give criminals an unfair advantage. This is a journey into the upside-down world where the line between justice and absurdity is dangerously thin. 1. Let's kick things off with a classic: the burglar who sues you for his injuries. Thanks to a fascinating legal concept called duty of care, you can't turn your home into a real-life version of the movie Home Alone. If an unsolicited home entry specialist pays you a visit and takes a tumble down the rickety staircase you've been meaning to fix, he might just own that staircase and your wallet by the time his lawyer is done. The law basically argues that your right to property doesn't include the right to create a death trap, even for people who are actively trying to liberate your television. 2. In Germany, escaping from prison is considered an exercise of your basic human instinct for freedom, not a crime. This means if an inmate pulls off a brilliant Shawshank-style breakout, they won't get extra time added to their sentence for the escape itself. It's not a crime, it's just an enthusiastic, self-administered early parole. Now, if they steal a car or knock out a guard on the way out, that's a different story, but the simple act of leaving is met with a legislative shrug that seems to say, "Hey, we get it. We wouldn't want to be in here either." 3. There's a legal cheat code called fruit of the poisonous tree, and it's a prosecutor's nightmare. It means if cops get evidence illegally, say, through a bad warrant or an unconstitutional search, that evidence is the poisonous tree. Any other evidence they find because of that first mistake is the fruit, and the whole rotten harvest gets tossed out. It's the law's way of saying two wrongs don't make a right, but they can definitely make a guilty man walk free. The mob boss, whose secret ledger was found because of an illegal wiretap, he's a free man. Justice, it turns out, is a very picky eater. 4. Florida's shoplifting laws seem to be designed by someone who really appreciates a long-term plan. The state distinguishes petty theft from a serious felony based on the value of goods stolen in a single incident. This allows a disciplined thief to hit the same store every day, stealing just under the felony amount each time. It's basically a crime subscription service on the misdemeanor monthly plan. They can accumulate a warehouse of stolen goods, but as long as they do it in these polite, bite-sized chunks, they'll only ever face a slap on the wrist. 5. A criminal can get a law thrown out by arguing that it's just too stupid to be understood. This is a real legal doctrine called void for vagueness. If a law is written so poorly and ambiguously that a person of average intelligence can't figure out what is being forbidden, it can be struck down as unconstitutional. So, a criminal can walk free not because they're innocent, but because the government that wrote the law against them was fundamentally incompetent. 6. Committing a crime you don't remember and couldn't control sounds like a movie plot, but it's a real legal defense: automatism. This argues that a person's actions were involuntary. This isn't just about being distracted. We're talking about situations where a medical condition causes a person to act without any conscious thought. For example, a person with a severe sleepwalking disorder who breaks a window, or someone who has an unexpected seizure while driving. If it can be proven that they were acting like a robot on autopilot, with no conscious control, the law can find them not criminally responsible. 7. Want to own a house without the hassle of paying for it? The law offers a painfully slow but surprisingly effective method called adverse possession, also known as squatter's rights. If you illegally move onto someone's vacant property and stay there openly for a set number of years without being told to leave, you can actually sue to become the legal owner. It's the legal equivalent of calling dibs and having a judge back you up a decade later. Imagine the original owner's face when they find someone living in their house holding a deed with their own name on it. 8. The Fifth Amendment gives us double jeopardy, which means you can't be tried for the same crime twice. It's a vital protection, but it also works like a one-time-only get-out-of-jail-free card. If prosecutors fail to convict you on their first attempt, that's it. Game over. There are no do-overs. Even if you hold a press conference on the courthouse steps the next day and confess to everything on live TV, you can't be retried for that offense. Is it better to let a guilty person walk than to give the government a second shot to prosecute? 9. Switzerland is a country obsessed with precision and order. So naturally, their approach to life imprisonment is rather relaxed. The country has no such thing as life without the possibility of parole. The maximum a person will typically serve for even the most heinous crime is about 15 to 20 years, after which they are eligible for release. The philosophy is that everyone deserves a shot at rehabilitation. So in Switzerland, life in prison is less of a permanent address and more of a long-term correctional retreat with a firm checkout date. 10. Diplomatic immunity is the ultimate VIP pass for getting away with pretty much anything. High-ranking foreign diplomats and their families are often completely shielded from the laws of their host country. A diplomat could literally steal a priceless painting from a museum, and the local police would be powerless to arrest them. The only recourse is to declare them persona non grata and politely ask them to leave the country with their stolen goods. Just how much crime should we tolerate for the sake of not offending another country's ambassador? 11. Ever heard the phrase, "Time heals all wounds"? In the legal world, it can also heal a criminal record. It's called the statute of limitations. For most crimes, excluding the most severe like murder, a prosecutor only has a certain number of years to file charges. If they don't, the criminal is home free, forever. You could pull off a multi-million-dollar art heist, and if you can just hide out on a beach long enough for the clock to run out, you can legally come home and brag about it. The law basically has a memory limit. 12. The justice system loves a fresh start, especially for young offenders. That's why juvenile records are often sealed or expunged once the person becomes an adult. The idea is to allow them to move on without being haunted by a youthful mistake. The absurd part? This fresh start can completely hide a long and violent history. An employer, a landlord, or even a new partner might have no way of knowing that the person in front of them has a past filled with serious offenses because the law has decided to press the delete button on their history. 13. Sometimes the law agrees that breaking the law is the right thing to do. This is known as the necessity defense. Imagine you're stranded in a blizzard and break into an empty cabin to avoid freezing to death. You've committed breaking and entering, but you can argue it was necessary to prevent a much greater harm: your own death. In this scenario, the law protects you from punishment. It's a rare and fascinating loophole where criminality becomes the legally correct choice. 14. The entrapment defense is a wild one. It's when a defendant argues, "I only committed this crime because the government basically tricked me into it." This isn't just an officer giving someone the opportunity to commit a crime. This is when law enforcement coerces or persuades someone to commit a crime they otherwise wouldn't have. It creates a bizarre situation where someone is factually guilty, but they get to walk free because the police were too good at their job of catching criminals. How far should law enforcement be allowed to go to create the very crime they want to solve? 15. A few years ago, a defense team for a wealthy teenager argued that their client suffered from affluenza. The argument was that he was so spoiled and rich, he couldn't understand the consequences of his actions. And it worked. Instead of a long prison sentence for a deadly incident, he got probation. This case created a firestorm because it suggested a disturbing legal precedent, that being too privileged can be a defense for criminal behavior. It's the ultimate get-out-of-jail-free card, available only to the 1%. 16. You can't be guilty of a crime if you didn't know you were committing it. This is the mistake of fact defense. For example, if you borrow a friend's jacket from a party, genuinely believing it's yours because it looks identical, you haven't committed theft. You made an honest mistake. While it makes sense for small things, this defense can be used in much bigger cases, forcing a jury to decide not what a person did, but what they were thinking when they did it. A notoriously difficult thing to prove. 17. The legal system is obsessed with reliable evidence, which leads to the hearsay rule. In simple terms, a witness can't testify about something they didn't see or hear themselves, but were told by someone else. So, a witness saying, "The defendant told me he did it," might be allowed, but "Our friend Bill told me the defendant did it" is hearsay and usually gets thrown out. This rule is designed to prevent gossip from being used as evidence, but it can lead to the absurd result of a crucial piece of the truth being legally ignored. 18. For many white-collar criminals, bankruptcy isn't a punishment. It's the final step of the heist. Someone can defraud investors out of millions, live lavishly, and then, when it all comes crashing down, declare bankruptcy. This legal process can shield their remaining assets, like their primary home or retirement accounts, from being seized to pay back the victims they ruined. It's a perfectly legal way to say sorry for your loss while sitting in a mansion the victims technically paid for. Should the law protect a criminal's nest egg from the very people they victimized? 19. There is a place you can confess to a crime with absolute legal impunity: a church, temple, or synagogue. It's called the clergy penitent privilege. A person can confess the most heinous acts to a religious leader, and that leader cannot be forced to testify in court. It's a shield even more absolute than doctor-patient confidentiality. The law considers the sanctity of that confession to be more important than the information it contains, turning a sacred ritual into the perfect legal black hole for a criminal's secrets. 20. The insanity defense is one of the most controversial concepts in law. It doesn't argue that the person didn't commit the crime. It argues that, due to a severe mental disease, they were unable to understand that their actions were wrong. A successful insanity plea doesn't mean the person walks free. They are typically committed to a secure psychiatric facility. However, they can be released if and when they are deemed to be no longer a danger to society, which could be years before a standard prison sentence would have ended. 21. The American justice system isn't so much a majestic court as it is a bustling flea market where the main currency is prison time. This is called plea bargaining. Over 90% of criminal cases end this way. Instead of a dramatic trial, the prosecutor offers the defendant a deal: plead guilty to a lesser crime, and we'll forget the really bad stuff you did. It's an efficient system that protects criminals from harsh sentences and protects prosecutors from the terrifying possibility of actually losing a case in front of a jury. Justice, it turns out, is negotiable. 22. In most of the United States, you have no legal duty to rescue. This means if you see someone in dire peril, the law says you can just watch. You could see a man dangling from a ledge, and as long as you didn't put him there, you can legally pull out some popcorn and see how it ends. This protects the ultimate criminal, the person who commits the crime of monstrous indifference. The law won't punish you for doing absolutely nothing, even when a little help could have saved a life. 23. You know the words, "You have the right to remain silent." These are the Miranda rights, and they are a criminal's best friend. But the real magic isn't in the rights themselves. It's in the technicalities. If a cop messes up the wording, gets the order wrong, or forgets a single line, any confession that follows can be thrown out of court. A criminal could give a 4-hour, tearful, videotaped confession, but if the officer flubbed the preamble, it's like it never happened. It's the ultimate grammatical get-out-of-jail card. 24. Ever wanted to get into a fist fight without getting arrested? There's a legal concept for that. It's called mutual combat, and it exists in several states. If two people willingly agree to fight, it can be a valid defense against assault charges. It's the law's way of saying that if two idiots consent to sorting out their differences the old-fashioned way, it's not the court's job to play referee. So, the next time you're about to get in a brawl, just make sure you get a clear yes first. Is this a legal defense or just state-sanctioned stupidity? 25. Let's talk about the superpower of silence, otherwise known as pleading the Fifth. The Fifth Amendment protects a person from being forced to incriminate themselves. This allows a defendant to sit on the witness stand, look the jury in the eye, and refuse to answer a direct question about their involvement in a crime. It is the most legally sound way of saying, I would love to answer that, but the answer would be very, very bad for me. 26. Evidence in a criminal case has to have a clean chain of custody. This means there's a perfect, unbroken record of who handled the evidence and where it's been. But if that chain has a single broken link, if Officer Bob stored the bloody knife next to his lunch and forgot to log it, the evidence can be declared inadmissible. A mountain of proof can be flattened by a molehill of shoddy paperwork, allowing a criminal to walk because someone forgot to sign a form. 27. The law sometimes agrees that rage is a pretty good excuse. It's called the heat of passion defense. If a person kills someone in a moment of sudden, intense anger after being provoked, this can reduce a murder charge to the lesser crime of manslaughter. It's a legal acknowledgement that sometimes people just snap. While it makes a certain kind of emotional sense, it's also a law that literally offers a discount sentence for committing the ultimate crime, as long as you were really, really mad when you did it. 28. When the facts aren't on your side and the law is against you, there's one last desperate defense. Just confuse everybody. A skilled lawyer can introduce so many complex, irrelevant, and emotionally charged arguments that the jury simply loses the plot. The goal isn't to prove innocence, but to create so much doubt and mental fog that the jurors can't agree on guilt. It's a strategy of weaponized confusion, and when it works, a criminal is acquitted simply because the jury's collective brain shut down. 29. Getting written into an elderly relative's will is a lot easier than you think, especially if you're the one taking care of them. The law calls this undue influence, where a caregiver manipulates a vulnerable person into changing their will. But proving it is incredibly difficult. A criminal caregiver can spend years isolating their target, only to claim the inheritance was a loving gift. The law has a very hard time telling the difference between genuine affection and a very patient, very clever predator. 30. A search warrant is the golden ticket for police to enter a property. But that ticket is only valid if it's filled out perfectly. If a judge writes the address as 123 Fake Street when the suspect lives at 124, or gets the date wrong, the entire search can be deemed illegal. Any evidence found, no matter how incriminating, gets thrown out. Criminals have walked free not because they were innocent, but because a judge's penmanship was a little sloppy. It's proof that sometimes a typo is more powerful than a SWAT team. 31. In some states, if you're attacked outside your home, you have a duty to retreat. This means that before you can use self-defense, the law requires you to try and run away if you can do so safely. In essence, you have a legal obligation to prove you're not a hero. If you stand your ground and defend yourself when you could have fled, you could find yourself charged with assault. It's a bizarre rule that can put the victim on trial for not being a good enough coward. 32. The Witness Protection Program is the ultimate loyalty rewards program for criminals. If you're a high-level criminal and you agree to testify against your even more criminal boss, the government will thank you by giving you a brand new life. They'll erase your past, give you a new identity, and set you up in a new town, all on the taxpayer's dime. You could be a career criminal one day and a mild-mannered accountant in Ohio the next, all because you were the first one to snitch. 33. A jury has a secret superpower called jury nullification. It means that even if a defendant is clearly, undeniably guilty, according to the letter of the law, the jury can just acquit them anyway. They can do this for any reason. They think the law is unjust, they feel sorry for the defendant, or maybe they just didn't like the prosecutor's tie. It's the nuclear option of the jury box, allowing 12 random citizens to override the entire legal system based on nothing more than a gut feeling. 34. In the American legal system, freedom has a price tag. It's called bail. If you're arrested, a judge sets a bail amount. If you can afford to pay it, you get to walk free until your trial. If you can't, you stay in jail. This creates a wonderful two-tiered system where a wealthy person accused of a serious crime can go home to their mansion, while a poor person accused of a minor offense can rot in a cell for months. It's less about guilt or innocence and more about the size of your bank account. 35. Imagine telling a judge two opposite things at once. "I didn't do it," followed by, "but I'll take the prison sentence." That's a real thing, and it's called an Alford plea. It's a bizarre but strategic move where a defendant maintains their innocence but formally admits the prosecution has enough evidence to likely get a conviction at trial. So, to avoid the risk of a much longer sentence, they agree to be punished for the crime they publicly deny committing. It's a pragmatic deal that protects the criminal from a devastating trial loss, while letting them save face by never actually confessing. Everyone wins, except maybe the concept of truth. 36. The concept of honor among thieves is a myth, and the court system is proof. Criminals can, and often do, sue each other. A getaway driver could theoretically sue the bank robber for not paying him his share of the loot. While the case might be laughed out of court, it has to be filed and heard like any other contract dispute. The law provides a formal process for criminals to complain when their criminal conspiracies don't go according to plan. 37. Thinking of starting a criminal enterprise? You might want to get married first. In the United States and many other countries, a legal concept called spousal privilege can act as a powerful shield for a criminal. It generally prevents one spouse from being forced to testify in court against the other about confidential communications that happened during their marriage. This means the one person who might know everything, the accomplice, the confidant, can legally refuse to say a word. The law essentially values protecting the sanctity of a marriage over getting to the truth, even if it means a key witness is silenced and a guilty person walks free. 38. For the sophisticated criminal, getting caught is just a minor business expense. That's because they use things like asset protection trusts and offshore shell corporations to hide their money. A fraudster can have millions stashed away in a complex legal web. So even when they're convicted, prosecutors can't touch the vast majority of their illegal earnings. The criminal goes to a low-security prison for a few years, knowing their fortune will be waiting for them when they get out. 39. Justice isn't just blind, it's also a lottery. Two people can commit the exact same crime in the same state and get wildly different sentences. One might get probation while the other gets a decade in prison. The outcome can depend entirely on the specific judge they get, the mood of the prosecutor that day, or the skill of their lawyer. This randomness, known as sentencing disparity, means that some criminals get a lucky break while others pay a far heavier price, all for the same offense. 40. Forgetting your past is easy when the law agrees to forget it with you. The process of expungement allows a person to have their criminal record legally erased. Once a record is expunged, it's as if the crime never happened. The person can legally say they have never been convicted of a crime on job applications or housing forms. While it's a great tool for people who've made a single mistake, it also allows those with more serious patterns of behavior to present a clean slate to an unsuspecting world. 41. There's a group of people who have achieved the ultimate legal life hack. They've simply decided the law doesn't apply to them. They're called sovereign citizens. They believe they are immune to all government authority and will bury courts in mountains of nonsensical paperwork filled with bizarre legal jargon. While they almost always lose, they exploit the system's obligation to hear them out. Their defense protects them by turning the justice process into an exhausted, paper-logged circus, hoping the system will just give up. 42. The law doesn't sweat the small stuff. This is a real principle called de minimis non curat lex. It means a court won't bother with an issue that is incredibly minor. But this can be a criminal's best friend. A thief could steal something of trivial value, and a prosecutor might not press charges because it's not worth the court's time. It's a legal shield for low-ambition criminals, ensuring that if you're going to commit a crime, make it an insignificant one. 43. If you can't find evidence to support your innocence, why not just buy it? In a high-stakes trial, a wealthy defendant can afford to hire an army of expert witnesses. For the right price, you can find a credentialed expert who will testify that the sky is green. This buries the jury in conflicting facts, creating a fog of reasonable doubt. It's a brilliant strategy that protects the criminal who has enough money to shop for the reality that suits them best. 44. Be careful if you ever try to be a hero. In many places, if you voluntarily help someone in an emergency, say by performing CPR, and you accidentally injure them, you can be sued. These aren't Good Samaritan laws. This is Good Samaritan liability. This fear of being sued causes people to hesitate or do nothing at all. This inaction directly benefits the original criminal, the one who created the dangerous situation in the first place, by ensuring their victim might not get the help they need. 45. The castle doctrine says you can use force to defend your home, but in the hands of a clever aggressor, it can become a license to commit violence. A person can provoke a conflict, lure their enemy onto their property, and then, once the confrontation turns physical, claim they were just standing their ground. The law, designed to protect homeowners, can be twisted to shield a person who masterfully engineered the entire violent encounter from start to finish. 46. A corporation is legally considered a separate person, which creates something called the corporate veil. This is a powerful shield for the actual humans running the company. If a corporation commits a crime or causes massive harm, you can sue the company itself, which might just be an empty shell with no money. It can be incredibly difficult to pierce the veil and hold the individual executives who made the decisions personally accountable. They get to hide behind the company's logo, often walking away from the wreckage without a scratch. 47. Here's a law that seems tailor-made for con artists: the statute of frauds. This ancient rule says that certain types of contracts, like those for the sale of land or goods over a certain value, must be in writing to be enforceable. So a swindler can make a grand verbal promise, shake on it, take someone's money, and then simply deny the agreement ever existed. If there's no paper trail, the law basically pats the con artist on the back and tells the victim, "Should have gotten a receipt." 48. The Constitution guarantees a right to a speedy trial. This is meant to protect people from languishing in jail for years. But for a guilty defendant with a good lawyer, it's a ticking clock they can use to their advantage. They can file endless motions and create constant delays, dragging the process out. If the prosecution can't get its case together in time and violates that speedy trial clock, a judge can dismiss all charges. The criminal wins not by being innocent, but by being an expert at wasting time. 49. The exclusionary rule. In simple terms, if police obtain evidence by violating a person's constitutional rights, like an illegal search, that evidence is excluded from trial. It doesn't matter if they found the murder weapon, a signed confession, and a PowerPoint presentation titled "My Evil Plan." If the cops broke the rules to get it, the jury will never see it. It's a law that deliberately protects the guilty to punish the police. All right, 49 points down, just one to go. But before we get to it, it's time for the final verdict. The award for the most absurd legal protection on this list has to go to the Affluenza defense. Why? Because it's the only argument that successfully turned a life of extreme privilege into a get-out-of-jail-free card. The defense essentially argued that being too rich and spoiled made the defendant unable to understand consequences. It's a concept that protects a criminal not despite their wealth, but directly because of it. Do you agree? Or did another law on this list feel more unjust? Let us know your pick in the comments. And now, our final number. 50. The single greatest law that protects the criminal is the very bedrock of the entire American justice system, the presumption of innocence. The phrase, "innocent until proven guilty," isn't just a nice idea, it's a shield of armor. The entire burden of proof is on the prosecution. The defendant doesn't have to prove they're innocent. They don't have to say a single word. They can sit there while the state throws everything it has at them. And if the state's case has even one crack of reasonable doubt, the defendant walks. It is the most important right we have, and by its very design, it is and always will be the ultimate protection for the guilty. So there it is. A journey through a legal system where logic often takes a backseat to procedure, and the absurd can become law. We've spent this time highlighting what seems indefensible. But now, we have a question for you. Look back at our list and tell us if there is one law that you believe is actually completely reasonable and necessary. Scan the list again, find the one you would defend, and explain why in the comments. If you enjoy videos that challenge the system and make you think, show your support by hitting like and subscribe.